We are live on Facebook, Rumble, Twitter, Twitch, YouTube, and Telegram, and we're also creating, or we have created, an Instagram as well as we're going to be creating a TikTok soon, so we'll have no new platforms we'll be streaming from, folks. Welcome, thank you for joining us. We are here on episode 48 of Campaign for America. That's almost 50 episodes. Wow, that's a lot. Today we're going to be doing a restream on CPS case corruption issue. There's a man by the name of Roman Brik, and we're going to be restreaming somebody else's podcast on this issue. Dennis is recovering from a cold at the moment, so we're going to do that. But we encourage you to call in while we're streaming this and talk about it. So with that being said, let me read our disclaimer. Then we'll play our intro, and then we can begin. The views expressed on this show are expressly the views of the speaker and do not necessarily reflect the views, beliefs, or opinions of newsforus.world, its hosts, broadcasters, or affiliates. Remember, folks, always use your own discernment when viewing. We encourage our viewers to think for themselves.
In 1980, Ronald Reagan wore a white suit, a red tie, and a white shirt and addressed the nation. Hi, I am Dennis Andrew Ball, and I am running for President of the United States. I am talking to you right now because the debates that were conducted this week need to have a presidential response. The economic issues that both Barack Obama and Mitt Romney answered created in the minds of many of us unanswered questions of how do you sustain economic growth in the United States of America. In light of the decisions and the events that have happened since 2008, what do we need to do to reduce the deficit, increase job creation, maintain Social Security and Medicare, and provide the opportunity for our children and future generations not only to survive, but to thrive in a global economy. I would like to talk to you quickly on how I perceive what needs to happen. The United States of America at this time is suffering because the means of production have not equaled the ends of production that it requires in order to sustain its middle class. The United States of America must reindustrialize itself to make it possible that 23 million Americans can go back to work in industries that are productive for themselves and their families. What we are witnessing on a daily basis is the demise of the American family, the traditional American family, of children, parents, and grandparents, by people in authority who have used, abused, and misused their positions to hurt our people. This must stop, and it will under my administration. The need at this moment of time is to get our organs of power in business to invest in research and development, to make it possible for industry to not only survive in America, but also to thrive. My attitude is that the production capability of the United States is equal to none. Our workers are very productive if given the opportunity, but they must be protected by government that concerns themselves with their best interests. And that has been a problem for many years in this country. My attitude also is that in order for our people to get themselves in a position to care for themselves and their children, we have to evaluate at this moment in time what is important for that to happen. And I believe that it will be more of a decision on the part of the American people when they go to the voting booth to decide who they think is best qualified to do that job. I believe also that we are in a position to make decisions that will impact the course of history and to bring about positive change in the lives of our family structure. I want to say that in order to do that, the means of production will have to be a top priority to reindustrialize the middle class and to provide the support for the future generations. I want to say this, that in terms of how we go about this business, the President of the United States should be very aware of what has happened and what needs to happen. My interest at this time is to educate through my administration of candidacy for presidency to make it possible for you to learn more about me and to decide if you are better off since the election of Barack Obama and the changes that need to happen in terms of the increase in gas prices, in food prices, the mortgage forfeitures that have happened since him, and also what we will do in the future to make it possible for more people to be employed out of 23 million who are not. Consider this opportunity to communicate to your friends and your neighbors my thoughts, and I look forward to hearing from you. I need presidential electors who will vote for me through the Electoral College when I win the states in this country to become your next president. God bless you, and God bless the United States of America.
Would you like to do some housekeeping real quick, and then we'll
Yeah, right. Let's talk quickly. We had the new billboards created. I have distributed them. I'm going to donors now. People like Kurt Warner, Hall of Fame quarterback of the St. Louis Rams and Arizona Cardinals. People like Pierce Brosnan. Pierce is a family man. He's known as 007 and a good person. He started from nothing.
Sorry.
And people like Mark Cuban, who just sold his interest in the Mavericks to, I believe her name is well, she's the widow of Sheldon Adelman, and it's Miss Adelman, and she bought Mark's interest. So the thing about it is, we're going to people who know what it means to start from nothing and to make a bunch, and people who have more of a humble spirit and are not an asshole, and we can communicate, and then they have friends, and their friends then come to the table too, because they see what we're doing.
You know what makes these, those kind of individuals not assholes is that they don't have the silver spoon syndrome.
You say it so well, Stephen. Right on. And so, this is how I'm being led. I don't think many people understand how I focus on doing what's necessary. And just the fact that we have almost now 48 episodes of the Campaign for America. I mean, that's amazing. I mean, all of these things.
It's almost 2 seasons of a show.
Exactly. And I mean, outside The Chosen, which is going to season 4, we're catching up. So, as it relates to today's show, we have Roman Brik, who is a Jewish lawyer from Israel, who had 2 children stolen in Manhattan, New York, by the court. You'll hear that. And he's interviewing a gentleman who has filed a class action lawsuit. He's an attorney, and we'll learn more about him. And I think it'll be very good. And if you want to call in people, talk for a few seconds, we can do that.
Yes.
I'm a little bit under the weather today. I'm just recovering from a serious viral infection, but I'm here because I think it's been 19 days since the last show. To keep these shows coming.
Yep. And we shall.
Right.
I had to attend to my mom last week, folks, so that's why we didn't ever end up having a show, because I have a trying to get her into the physical therapy facility that will benefit her the most, and you know how that can be with insurance and all that. Anyway, so that being said, let's begin the stream, and I will bring this up. I have it right here, and then I'll share, and we will start it.
Okay.
Feel free to call in, folks. Our call-in line is 702-482-8620. Call in anytime during the stream, and if you'd like to talk about this CPS family corruption issue and what we're streaming right now, or we're about to stream. So I would love to hear from your thoughts. All right, let's begin. This is by T. Matthew Phillips, and his interview with Roman Brik.
And we are live. We are live. So that was an introduction. I'm just checking on Facebook. That's actually live streaming with the slight delay. People are joining. That's amazing. We have, okay, 1, 2. We have all the likes. I guess people were waiting for that. So hello, everyone. I am here with the distinguished guest, T. Matthew Phillips, attorney at law. He put the title there himself. So that's that's the first ever live podcast that we are trying to create. We put the promos out right on my page, your page, and hopefully people will join. So it's been a live stream simultaneously to Facebook and YouTube. Whoever joins will be able to take comments, and that's the idea, to make it as interactive as possible. The title. Let me go to the titles. We're also testing the software, actually a very good platform, StreamYard. So there's a banner that shows the idea, the main topic of the show: federal class action, family court tyranny, and more. We have a lot to talk about more. But without further ado, TMP, take it from here.
Oh, I gotta say, I don't know where to begin. I'm so excited here. The news from the James Webb Telescope about possible signs of life on planet K218b. This is incredible. This isn't a planet that's like 120 light years away. It's more than 8 times the size of Earth, and chemical scientists have found signs of dimethyl sulfide in the atmosphere, which is produced chiefly by phytoplankton, and they've also found CO2 and methane, which tends to suggest it has a liquid ocean. And oh, this is for family Hey, Court, I'm sorry. I think
Yeah,
I
you
have the
dialed into
wrong
the
script.
science
Sorry.
fiction.
I'm sorry. Okay.
Very,
No,
that's
this
why I
is
have
not James.
that's
So
why I
we're
have the
here to
ticker,
talk
you know.
about.
Right.
Yeah, yes, I should have noticed
Was he
that.
trying to be funny there?
But we're here for speedy
I don't know,
access to
Steve.
justice, in the immortal words of Saul Goodman, aka Jimmy Gill, McGill. But the point is, we wanted to talk about the family court, and we want to put the true message out there because the general public needs to know this. We need to be on Netflix, and it's going to happen because we're going to get the word out. Because the truth is, if I could be serious for a moment, there's a Holocaust going on, and they are taking away children like it's lunchtime. It doesn't matter if it's Staten Island in New York City or Las Vegas, Nevada.
Yup.
And I've studied the Holocaust formally, but pretty extensively. And one of the things you hear about the survivors that they talk about, there's no children anywhere. The children are not there because the children were, eliminated as soon as they got off of the railroad boxcars. And people would lament the sound of not hearing the laughter of children. The survivors would lament the fact that you don't hear children's voices. It's psychologically devastating. And I think it's all the more so when it's your own children that are not that have gone missing. They haven't gone missing, they've been taken and part of a Cash for Kids operation. And I am bound and determined to get this message to the general public. And I'm excited to be working with a fellow who I think is every bit as bright, witty, and perceptive as Mark Twain himself. And ladies and gentlemen, I give you Mr. Roman Brik.
You're too generous with your compliments, but the first thought that that's a very creative intro, like everything that you do. I thought that the real question is whether there are signs of life in family court, right? But I think your client here,
That was funny.
Jason, actually, that's an exciting way to start, with this new feature. And again, we want to make it as interactive as possible. So he has a comment here. Let's send all the family court judges and lawyers in a one-way ticket to this new planet. So
I love that.
Yeah, you clearly hit the nail on the head with this introduction, Matthew. So I feel that's actually a good segue to the key topic that when we talked online that we would like to cover, right? And then we'll branch off to whatever maybe the audience wants us to take. But Jason is the named plaintiff in a very interesting legal action that you brought. I think it never happened before in the California federal court, right? So maybe you can start there.
I'd love to thank you for that. I was going to say, I'm told that it's the shortest class action on file in the Central District of California. One of the things I'm most proud about is that the lawsuit is, at least in my way of thinking, very succinct. And I would urge all people that are hearing this that happen to be litigants in family court, you can say it really short and really brief. And I think we demonstrated that in the class action. I've had the opportunity to work with several folks out in California to try to do a class action. That was the first goal, was to try to do a collective sort of action, kind of like with the collective bargaining mentality. Mm-hmm. But it was hard to come up with a class action because a class action lawsuit, of course, requires a commonality in the fact pattern. There has to be common questions of fact that are interwoven among all the parties and prospective plaintiffs. And there has to be the same issues of law. And I think we have it here. In terms of facts, all of the plaintiffs share the same factual basis, which is they have been terminated of their right to custody, despite the fact that they've never been found unfit. And what I mean by unfit is the state, state of California has never instituted fitness proceedings against my clients. There's never been a case, for example, of California versus D'Souza, where the state is alleging child abuse, child neglect, child endangerment, or child abandonment. It simply never happened. Now, there may be disputes between Jason and his ex, and that's fine, but there are no allegations of harm to the minor child. And I think that's important. If there's no allegations of harm to the minor child, then under Supreme Court precedent, which is binding in all 50 states, in all trial courts, and all family courts, according to Supreme Court precedent, they can't take away your child unless you've actually been found unfit pursuant to a properly noticed fitness proceeding where the state alleges child abuse, child neglect, child abandonment, or child endangerment. Now, this fact pattern is common to all 10 plaintiffs. They've all been summarily divested of their custodial rights, despite the fact that they have never been found unfit, nor are there allegations of unfitness. Again, there may be squabbles among the parents. This one did that, this one did the other, but there are no allegations of harm to the minor children, and certainly there are no findings that there's been any harm to the minor children. And the point is that if these people, I see the comment there, and thank you for that, Robert. Robert says that 50-50 shared custody should be the new standard. God bless you. I totally agree. I would add, though, that it's not really a new standard. The 14th Amendment has been around since at least, I think, 1868. And the 14th Amendment provides that similarly situated people must be treated the same. That's in the Equal Protection Clause.
Right.
If you have mom and dad, they're similarly situated, and if the courts actually applied the 14th Amendment, specifically the Equal Protection Clause, we would have 50-50 shared custody in 99% of all the family cases. And of course, that 1% would be a situation where some parent was found, you know, in a fitness proceeding of having done child abuse, child neglect, child abandonment, or child endangerment. But again, that's never happened with my clients, and therefore there is no basis, no legal basis, and certainly no factual basis by which to divest custody. And, you know, footnote, the other side always says, well, your clients haven't been terminated. They still have a right to make a Zoom call or something like that. Well, that's not parenting. That's right. The bottom line. We know what parenting is. Parenting is defined by the Troxel case. Troxel versus Granville, a Supreme Court decision from the year 2000, which says very simply that fit parents are presumed to be acting in their best interests. And custody is defined as when you have the right to care, custody, or control. That is the 14th Amendment liberty interest, known as the right to rear children, the right to bring up children. That is the right to care, custody, and control. And if a person only has, you know, a Zoom call access, well, they're not able to care for the, excuse me, they're not able to care for the minor child. Certainly they don't have any custody of them. They can't drive them to school or anything. They have no control. They can't tell them to say their prayers or brush their teeth before they go to bed. The truth is that a Zoom visit is not parenting. There's no actual parenting time, and every state I know of, I'm only licensed in California, but all states have public policies, as does the federal government, of keeping families together. That has to be the primordial concern, but we see otherwise. The facts are showing that they're taking away kids, and they do it. The judges understand that they are in the business of creating non-custodial parents. Much like creating ball bearings in a ball bearing factory. But anyways, I know I'm kind of going on a roll. But
no, that's very interesting.
Yes,
I just, I want to make it, to the extent, the audience participates, and it seems that, we have an actively engaged people here. Yeah, 13 people are watching. We are getting a lot of likes. That's encouraging for a first show. So I have the complaint here on the screen, and some people, that's the beauty of a podcast, because some people will watch, some people will listen later. So I think it's important to spell out for those who are listening how they can find the case, right? Because I have a Pacer account, but anyone can open a Pacer account, and the case is 223-CV, which is a civil case, right? -08230. So, and you filed it in the Central District of California, federal court,
Yes.
federal district court, with 10 plaintiffs. So I see the case is now pending, and it's moving into the summons stage, right? So maybe we can talk a little about mechanics, because I myself, I did file multiple federal complaints. I have actually 2 actions pending and 1 appeal in the Second Circuit. And I am pro se, even though I think people know, those who follow me, and I'm grateful for everyone who follows, but I actually did practice law in my prior life. Unlike my friend Matthew here, I tried to get away from the practice, but I was dragged back in, courtesy of family courts in the state of Washington and the state of New York. I'm not practicing law, I'm not giving any legal advice, but I am somewhat knowledgeable pro se, so it can be intimidating, right? Can be very intimidating to go to federal court, but it doesn't have to be. So, of course, there's the class action aspect. I think it's very, very novel here, and that's what if we can maybe focus on that, because a lot of people talk about bringing class action, but I believe that you are among the first who actually did that. Let me just look up a couple comments here, but I want to take the conversation, if we may, into the novelty of it, because I did sue my judge judging my case, Jeanette McFarland, and the previous judge who actually resigned or moved from my case after I sued him in federal court. And the regular claim that comes up is immunity, absolute judicial immunity. What are your thoughts and your strategy? How you expect to overcome that hurdle?
I have a lot of thoughts, and I could talk extensively about judicial immunity. But let me say, if I could say anything, in terms of just sharing my experience, courts always will cut slack for pro se litigants, and I think that's even more so true in federal court. Sometimes I've noticed maybe state court judges, they're really not at the caliber of federal judges, who of course are appointed by the president. And what's curious is, in this case here, I wanted to add, my clients are delighted with the judge that we got. I'm sure all the judges would be fine, but as it turns out, we got a judge who was appointed by Ronald Reagan. This is back, I think, in 1986 or 87. So that's kind of a remarkable thing, that to have somebody who's was appointed, that many years ago, and we're just very excited. But regardless of what judge you get in federal court, I've noticed federal court will give certain leeway and leniency, and I know this myself because I've litigated as a pro se litigant on my own behalf. And even though I'm an attorney, and I always, you have to disclose that you're a lawyer, but they still are willing to cut slack, so to speak. So what I would say to everybody is, don't be intimidated. Just remember, there's a reason they call it a brief, because you want to keep it, limited. I just think, as a general rule, if somebody sees a motion or a pleading or a complaint that has 129 pages, it's really kind of off-putting. And I was mindful of that when we did this complaint. And again, I'm proud to say it's only 14 pages long, including the verification and
I'm scrolling through that right now. It's short and sweet, and you cited the control and precedent, right? That's amazing. Yeah, so it doesn't have to be complicated. Yeah. So okay, so that this is great. Let's go. We get actually a lot of comments, which is I like it, because thank you very much for those who. So let's maybe just go through them, if you don't mind. That's a new format, right? So we'll see how it develops. Finish the point that Robert made. Yeah. So Robert says here. Yeah, he says that 50-50 shared custody should be the initial presupposition, right? And then family court judges have way too much power. Yeah, that's a given. John is a fellow father from New York here. He's a tremendous supporter of the cause, saying thank you. Mark Fishman has a very interesting comment. So Mark Fishman is another litigant who successfully so far took his case into our local federal court here in New York, and he was able to overcome the initial threshold that every federal plaintiff or litigant faces, especially pro se, and that's motion to dismiss, right? So let's just read a comment. Thanks for suing federal court to support and advocate for all parents' right to parents free of state control interference. So that's a topic that we have to cover, the government interference and where it all ties ideologically, because I know that you love the topic and I love the topic, right? I was born in a communist country. I moved from state to state. The communism always followed me. So this is something that we have to talk about. Maybe I need to stop moving, but there's no. America is still the greatest country on earth. We still have the Constitution. The First Amendment is still respected, but the way it's going, it's not very. There's no ground to be very optimistic. So, Christina, thank you for your comment. We'll get to it later. That's great. Let's just finish with what Mark has to say here. So he says, hope you pass sovereign state court immunity. You see the comment, right, Matthew?
Yes, I do.
What can you say?
You know what I say about immunity? It's there's no statute anywhere that says judges get off the hook. There's just not any statute. This comes from the notion that you can't sue the King of England if you're an Englishman, or I guess Englishwoman also. But there's sovereign immunity.
Didn't this country fight a revolutionary war and won against absolute monarchs?
Yeah, thank you. Yes. Yeah, and it's but I guess the notion is they say that they want judges to be able to do their job without looking over their shoulder, worrying about liability. But then I worry about that every day. I look over my shoulder, hoping I'm not going to get sued, or So the point is, I don't think there's really a good reason for it. And I would say something else also. A lot of folks bring up 18 USC 242, and you may be familiar with that statute. Again, 18 United States Code, Chapter 18 United States Code, Section 242. First of all, let me say that's a criminal statute. It's not a civil, but a criminal statute. Means that we as pedestrians, civilians, we can't proceed under that statute. You can't sue under that. But it's the kind of thing that the government attorney, the United States Attorney's Office, could prosecute judges criminally, because these things, the remedies call for sanctions under 18 USC 242. They call for criminal, incarceration, and even the death penalty if somebody takes away rights, like the 14th Amendment right to parent, under color of law, and it results in a kidnapping. The federal judge has, in the criminal court, would have a discretionary right to impose the death sentence. So first of all, let me say that 18 USC 242 is a very severe statute, and if the United States government proceeded against a judge criminally under 18 USC 242, I don't know whether a judge would be able to say, I'm immune, sorry, I have immunity, you can't prosecute me. I just don't think that argument would fly. So why is it that the same fact pattern, where we allege that the judges violate our rights under color of law and it results in a kidnapping because my child's being taken against, my will. So, I don't think they should have, for that reason. Again, there's no statute that calls for liability, and knowing they don't have immunity to criminal allegations, the same fact pattern in a civil context, there should not be, in my opinion, there should not be immunity. And what I found, though, kind of sadly, is that all judges are, they all are kind of cut from the same cloth, to the extent that they are cognizant of wanting to protect their brethren and sistren on the bench, it seems. That's my impression of the way it's gone down,
Judges
which is unfortunate, but I think
that's a class interest, and we need to get into a larger picture. Yeah, so that makes sense. Now, I want to acknowledge people who are actively participating and sharing. So thank you very much. We have female warriors here. Cadence is saying hi, guys. She runs a successful Facebook group, actually multiple groups. USA Family Court Class Action. I think your lawsuit made waves. You know, people shared it. I know that I shared it. It was very popular. Mary Catherine Skelly is saying hello, saying that's outstanding. So thank you very much. Can you talk a little bit about the Manel claim angle? Because that's something, you know, people heard about that, right? But this is a very interesting, and you have only one defendant, one respondent in your case, right? Who is this person, for those who don't know?
This person, the Patricia Guerrero, actually, well, the Honorable Patricia Guerrero, is the Chief Justice of the California Supreme Court. And as it turns out, the Chief Justice is the executive in charge of the Judicial Council of California. Now, who's the Judicial Council of California? Well, they are the state entity tasked with training judges. Just going back historically, when we were going to do the lawsuit, my clients contacted me wanting, without waiving any privileges here, they wanted to go after the counties because Orange County is producing all these judges that aren't following the law, and San Mateo County, and Santa Cruz County, Los Angeles County, San Diego County, Sacramento County. And so we say, well, wait a second, are all these counties? And, you know, if you do the deep dive, you soon realize the county has nothing to do with it. The people who are tasked with training the judges is usually a statewide body. And, you know, we were curious to learn, what are these judges, what are they being trained on? Because if you look at the family court bar, all the attorneys out there that are hustling clients, making all the millions, well, they never argue the Constitution. If you're, and I've heard this from hundreds of people, hundreds literally, if you try to get your attorney to talk about the Constitution, attorneys just won't do it. They're like, no, we want to do the belly crawl and do, 1 hour on the phone and then maybe 2 hours on Zoom and then the supervised visitation. Like, who wants to do that? That's because it must benefit the attorneys to string it out, So they never, and knowing that most of the family court judges were once family law practitioners, you have to believe the bench is staffed with judges that just don't know or are not willing to understand the Constitution. And I kind of understand it a little bit because, after all, custody is controlled by state law in all 50 states. There's no real federal custody laws per se. It's all done at the state level, and the actions are filed in state court. So I can see how, maybe they don't realize there's a federal dimension, but newsflash, there's at least 13 Supreme Court cases that set binding precedent that established the right to parent as a fundamental right. Specifically, and we have this in the lawsuit, it's part of the 14th Amendment liberty interest. Back in 1923, in the case of Meyer versus Nebraska, they said parenting, or the right to raise children, is a fundamental right. And it's remained, that precedent is undisturbed in 100 years. It's been exactly 1 century, 100 years. And yet, judges never follow it. Like, why not?
I have it on the screen. Yes, so you will have the complaint, the federal action, the federal lawsuit on your website, right? On your in your group, right, under your profile, yeah. I believe. Yeah. And I also will upload it to Fire Janet McFarland, the very popular Facebook group. We are approaching 400 people there, so please join. Please join my group, our group, the group of victims of Janet McFarland on Staten Island, Richmond County Family Court. So it's right there. So that's another aspect that in our talk offline. You mentioned that you don't claim any copyright, right? So you don't mind that the same lawsuit will be replicated in other federal courts, right? Because you as an affected father.
No, please, there's no such thing when something is published in the public domain, and the filing of a lawsuit is like publishing in the public domain. It means it belongs to everybody. Therefore, I can't claim any authorship in a copyright sense. And so anybody is free to plagiarize me. And this has actually happened to me before in another matter, and I'm very flattered when it happens, and I hope folks will bring this action in other states. And I think it's an argument that needs to be made. I think it's a winning argument. So I'm totally excited.
Yeah, and of course I meant it in a humorous way, but you as somebody who was affected, and to what extent you want to go into that, personal story, I can go to my personal story, but obviously we are connected to the cause, not just through legal curiosity, right, but by the facts of our life, and that's why it's so important to. Unfortunately, that's when the state continues to devour parents, it eventually comes to people who know what is going on and can resist and fight and expose in a more effective manner. So, like every time in history, the regime seeds the seeds, right? Just places the seeds of its own destruction. So they have a California licensed attorney who brought a federal class action, which is completely out in the open. We'll post it, and anyone in any federal district is welcome to take it. Right. So that's amazing.
Absolutely.
Now there's one aspect.
And just to
go ahead. Yeah. Sorry.
Oh no, please. I'm sorry. Go ahead. I didn't mean. I'm sorry.
No, it's like we are so excited about doing that, right? So we have a lot to expose and talk about. But there's one aspect that I would like to highlight, because that's when I started learning the topic, and of course it's multi-layered system of corruption, right? So nobody pushed back throughout the years of family court existence, and now it's ossified system of protecting the protection layers, one layer after another. So nobody ever resisted. So now it's our job actually to uncover that. But one of the many issues that I think we as people are facing is the class action. That's what I learned is an avenue that's reserved to attorneys. Isn't that right? So can I, with or without legal knowledge, bring a class action?
Well, you know what? I think, as far as I know, you have to be an attorney. I really can't speak for the other 49, but in California, you have to be an attorney to have a class action. But nevertheless, an individual could make these same allegations. I know there are hundreds of thousands. There must be. We estimate probably 400 California children lose a parent every day the court is open for business with the Cash for Kids operation. And you could make these allegations whether it's part of a class or not, because I believe, because this is Supreme Court precedent, it's going to be binding in all 50 states. And the point is that if you're a fit parent, meaning you've never been found unfit, then there's no basis to take away someone's children. I got to say also, someone asked me, they said, I never hear about fitness proceedings. Like, I've never seen or heard of, when do they, in my response, I kind of laughed when I thought about it. Well, they don't need to do fitness proceedings, because they have the family court judge who's going to take away the children like it's lunchtime, and that's another thing that really I see as so ironic, that when they take away children at the border, you have the ACLU, right? And it's funny, because I tried to contact the ACLU. The ACLU says, we don't do family court. Next thing you know, they're all aggrieved because children are being separated from their parents at the border. And the ACLU says, this is a quote, this is on their signs. The ACLU maintains that it's a crime against humanity. So that must be like Auschwitz or Dachau. It's a crime against humanity to separate parents from children. But I guess when you're doing it for Title 4D dollars, like the state of California does, then somehow it's justified. I mean, they're doing it for money. And one of the things I'm going to argue to the federal judges, this whole money angle, and I'm going to tell the judge, please pay California, what they expect. Just give them the money, whatever they want, just pay them. Just give us our children back. Because what they're doing is they're literally slicing bacon off the back of our children, fry it up in a pan just to make a little grease. It's just welfare dollars, Social Security money from the state. Just have the federal government pay them and just give us our children, and don't use our children as a pretext to get, federal, Social Security dollars. So that's my rant.
Excellent. No, excellent. So we have actually amazing engagement. So thank you everybody for joining. I think it's great for the first ever episode. Maybe we'll do more. And please opine or comment what you think. If you like what we're doing, maybe changing the format, how often maybe it should be done, every week, every 2 weeks, what are other topics. But I want to acknowledge people who are joining and commenting, because that's what makes the show interesting. So let me just pull a couple sentences here on the screen. So Dave asked for the case, and I made a banner. So everybody, again, the case and subject is 223 CV, civil case -08230. Jason D'Souza. Jason is a great father who is very active, very visible on the social media. He's the main plaintiff, but there are 10 affected parents. So that's a class right there. So Jason asked for that number. It's here. We're repeating for those who will listen to that. Let's see who else. I'm just pulling it online. So Viridiana is asking, can we sue a family judge if they took a separate real property under common law marriage? You have a comment on that?
I don't know if there is a common law marriage. I think the Marvin versus Marvin says, if you want to act like you're married, get married. But I'm not sure what I suppose, as a general rule, you can sue a judge when they act outside the scope of legal authority, meaning without subject matter jurisdiction. That's a general rule. When they act, actually the words of the Supreme Court from the case of Stump versus Sparkman, it says when a judge acts in the clear absence of all subject matter jurisdiction.
That's a horrible
perfect example.
Horrible case, right? The circumstances there are just outrageous, right? So there was an operation, right? Yeah.
You are correct. The facts are really atrocious. I suppose in mitigation, it's the woman who was sterilized did have a cause of action against her mother and against the doctor and against the hospital and the insurance company. The only person she didn't have a cause of action is the judge, for better or worse. And I'm critical of the decision for lots of reasons, but the one takeaway I would say is when it says clear absence of all jurisdiction. Let's say your family court judge, it's a Saturday night, they're both going to see the same new movie, Tom Cruise action thriller, and your judge rear ends you in the intersection. There's a vehicular collision. Well, if the judge is driving and crashes into you on a Saturday night, that would be the clear absence of all jurisdiction, which meaning you could sue your judge for personal injuries sustained in an auto accident. So, but when it happens on the bench, that tends to be something you couldn't sue for. If your judge were to block you on Facebook, I believe that gives rise to a cause of action. And I have an interesting lawsuit myself coming up in just a few here on that exact same topic. So this could be another show topic, suing your judge for censoring you on social media.
Yeah. I think there's a different angle of it actually pending in front of the Supreme Court. There were two district federal actually circuit courts that arrived to different conclusions, but that can definitely be another topic. Michelle is saying, I hope to see change. They're tearing families apart, criminals. Yeah, I think we can universally agree, at least the audience here. An interesting maybe clarification. Barbara is asking, why is this a civil case, not criminal, as interference of custody is criminal? So that's a federal. You want to take it, Matthew?
Well, we're bringing a civil case because, of course, my office is not a prosecutorial agency. I'm a private attorney, and these are civil allegations. So I guess that's the short answer to it. But and I think interference of custody, I could be wrong, but I think that's usually when one parent interferes, not when a judge. When a judge interferes, I think the big issue is whether or not they're taking away rights under color of law. And I think they are. In our case, we contend that they're doing that, and we contend also.
I just want to point out, folks, that this guy makes
that it's a policy of the state of California, and that's why
This guy, John Kemp, says the system is driven by money, corruption, and the agenda to break up families, which is true through the Title IV funding. Discussions and legal actions such as this are the way to expose this. And he's absolutely right, folks. Discussion and open debate and legal actions is how we move forward on this. And if they refuse to follow the law, we expose them via us. So I just wanted to point that out.
I know we were talking about the Monell claim. I was taking notes here, but we are bringing a Monell claim, and what that alleges is that it's the policy of the state of California to not train its judges on the constitutional safeguards and procedures associated with the 14th Amendment liberty interest called the right to bring up children. And it's probably not, well, I think it's fair to say there's no written policy within the state of California, but it's become a de facto policy that they take away children without any consideration for whether it's a constitutional right or not. And in fact, I've had judges tell me, I've wanted to argue a 14th Amendment, and I'll bring up some of the leading Supreme Court decisions. And, judges have say, we're not here to talk about the Constitution, and they'll go right back to the best interest standard, which to me is the most, silly, amorphous, vague, ambiguous standard there could ever be, because best interest, whatever the judge, it means, depending how much caffeine they have in their diet, how much fiber they have, best interest is just whatever they want at any given time, with an eye on taking away the children. Because if, and it's been said many times throughout history that, the welfare of the children is the same excuse that all tyrants give. Yep. Best interest,
That's how you evoke an emotional yeah.
Hey, Dennis.
So,
yes.
We're on at 58 minutes. Do you want to continue the rest of this on the next show?
Yeah, let's do that.
All right, cool. All right, awesome. Well, we will resume the last part of this, folks, on next week on episode 49, and we will field your questions as well. We're going to wrap up because we're getting close to the hour, folks, but thank you for joining us. Any last words before we oh, shit, my camera's freezing up. Let me fix it. Any last words, Dennis, before...
Well, I would just appreciate everybody's support. This is why we're people want to see change. And change comes by people who are active and consistent in the society. And these gentlemen are doing it and educating all of us on how to proceed. And I am. Thank you. And so is Stephen.
Yep. There's many of us in this fight. And what these guys are doing is absolutely right. What that one commenter said was that we need to expose this through discussion and legal action, and he's absolutely right. We need to keep pushing forward.
Before you go, Stephen, I just want them to know that I've just released my 64th book called Full Disclosure, We Are Not Alone. I think you'll find it very interesting on Amazon. It's a Kindle read right now. The paperback is in progress with the new cover.
Nice, awesome. I'm looking forward. Send me a copy. I'm looking forward to reading that. Oh,
I will. When I get it finally published in the paperback, I'll send you a copy.
Yeah, I got blue on my nose. I was eating some blue candy. If anybody's wondering what that is, that's what that is. Some sour candy. Sorry, guys. I didn't realize I got nose. All right. Thank you, everybody, for joining us. I'm going to play the outro, and we'll wrap it up. We'll see you guys next week.
Next week.